Tuesday, October 1, 2019, the first stage of the lawsuit between anti-affirmative action advocacy group Students for Fair Admissions and Harvard came to a close. Federal Judge Allison D. Burroughs, an Obama appointee, ruled that the college's admissions practices are legal. She cleared Harvard of all 4 counts of alleged wrongdoing: intentionally discriminating against Asian Americans, engaging in racial balancing, using race as a determinative factor in admissions decisions, and inadequately exploring race-neutral alternatives to achieve diversity. Ensuring diversity at Harvard relies, in part, on race-conscious admissions. Harvard's admission program passes constitutional muster, Burroughs wrote. The ruling came almost a year after a 3-week trial last October, and almost 5 years after SFFA filed the lawsuit in November 2014. The decision was a slam dunk for Harvard, according to legal experts. In her decision, Burroughs expounded on the value of diversity in higher education. She wrote that a heterogeneous student body promotes a more robust academic environment with a greater depth and breadth of learning, encourages learning outside of the classroom, and creates a richer sense of community. She also credited the stories of 8 current and former Harvard students who testified at the trial to that effect. Burroughs contended that so long as it is necessary, race-conscious admissions will always have a negative effect on certain populations, including Asian American applicants. Race-conscious admissions will always penalize, to some extent, the groups that are not being advantaged by the process, but this is justified by the compelling interest in diversity and all the benefits that flow from a diverse college population, she wrote. As long as that penalty is not discriminatory in nature and remains in line with the rules set by the Supreme Court, Harvard remains within the law. Burroughs wrote that she took admissions officers at their word regarding their testimony that there was no discrimination against Asian Americans, calling their statements consistent, unambiguous, and convincing. The lead attorney for Students for Fair Admissions, Adam K. Mortara, said he disagrees with how Burroughs handled the issue of discrimination. He cited a 2013 report by Harvard's Office of Institutional Research that found that Asian American applicants consistently receive lower personal ratings than applicants of other races. Personal ratings are numerical scores assigned to applicants based on abstract qualities like humor and grit. No one, not Judge Burroughs, not Harvard, has ever explained how it is that African Americans and Hispanics just have much better objective personal qualities than white and Asian applicants, Mortara said at the law school last week. He also alleged that Harvard runs a thinly disguised quota system for racial categories, which is illegal according to Supreme Court precedent. Though Burroughs ruled that the college's policies are lawful, she contended that the admissions process is imperfect and suggested a number of changes, including requiring admissions officers to participate in implicit bias trainings, maintaining clearer guidelines on the use of race in admissions, and monitoring any race-related statistical disparities. Just 3 days after the ruling, SFFA filed its notice of appeal to the First Circuit Court of Appeals. The next steps in the appeals process will be determined when the clerk of the First Circuit Court issues a briefing schedule dictating when briefs must be filed. According to the First Circuit Court rulebook, the appellant, Students for Fair Admissions, must file a brief within 40 days after the record is filed. Harvard, the appellee, will then have 30 days to serve a reply brief. After the briefing stage, a panel of 3 judges from the First Circuit Court will preside over the appellate hearing and begin work on a decision. After that ruling is handed down, the defeated party may choose to appeal again, either to the whole First Circuit Court or to the Supreme Court of the United States, which has discretion over whether or not it will hear the case. If the Supreme Court takes the case, the ruling has the potential to determine the future of affirmative action at private colleges and universities nationwide. University President Lawrence S. Backhouse said in a recent interview with the Crimson that he is confident Harvard will win in the First Circuit Court, but is uncertain about the university's prospects if the case heads to the Supreme Court, which is currently dominated by 5 conservative-leaning justices. My name is Camille G. Caldera, and I report on admissions and financial aid for the Harvard News.